our next guest, and not to forget, before that, my co-host today is Mark Z. Hi, welcome back, Mark.
Jeff, great to be here. Very intellectually stimulating
I
today.
feel very secure when you're at my side, Mark.
I'm honored.
Someone you know, and I hope I get this right, maybe you want to pronounce the name of the firm. I'll let you go for this one.
Well, we have David Kurtz. Dave is the senior partner at Constaggy, Brooks, Smith, and Profet. And Dave, thank you for coming on the show today.
Thanks for having me.
Hi, Dave. Why don't you tell us a little bit about the firm and what's the specialty of your practice?
Sure. So Constaggy, we are a labor and employment law boutique. The firm is based in Atlanta, Georgia. It's my attempt at a southern accent. We have offices around the country, about 175 labor and employment lawyers, and that's what we specialize in. If it's a legal issue that touches upon the employer-employee relationship, we handle it. So discrimination, non-competes and other restrictive covenants, wage and hour matters, whistleblowing, OSHA investigations, labor and employment issues arising in merger and acquisition transactions, traditional labor matters, as they're called, which is a code word for union-related matters such as elections, collective bargaining, unfair labor practice charges before the National Labor Relations Board. So again, pretty much if it touches the employer-employee relationship, my firm handles it.
Dave, does Constaggy focus on representing the employer or the employee?
We are exclusively on the employer side.
Excellent.
Tell us a little bit about that. What's the differences between working on the employer side versus the employee side? Are there any? I assume you made the choice actively.
I did.
Not you, but someone at the firm did.
At some point in my career. When you represent employers, you're part of it is about the kind of law you're setting. So, for example, the worst thing in the world you could do if you're representing employers, if you take a foray into representing an employee, and all of a sudden you've done really well on behalf of that employee in litigation, and you've set a precedent that has hurt all of your employer clients across the country, your clients aren't going to be too happy. So because you're actively working on behalf of one side of the aisle, that side of the aisle is where you have to put the focus of your practice. So that's why we do that. It adds a level of comfort for our clients. It allows our clients to know that we're on their team, and we're working together hand in hand with them. There's differences in terms of the fee structure and a lot of other business type reasons why people might make one choice or the other. But I'm on the employer side of the aisle. It's interesting. When I first started practicing labor and employment law, I was worried about that choice.
Interesting.
Will I be representing these big bad employers who have done these terrible things to employees? And then I actually started practicing, and I felt a little bit differently than I did coming in.
When you say you felt differently, you started getting down to some of the issues that are not black and white?
They rarely are. Most employers are trying to do the right thing. So somebody gets let go. Most of the time, there's a good reason for that. Sometimes there's not. And as an advisor for a company, I have to explain to them when they have a good case, when they don't have a good case, and how they should proceed. But what you learn is that there's often a lot of just misunderstanding. As somebody gets let go, they have trouble believing that
It's not
they
about
could have done
me.
anything
Right.
wrong.
It's not
right,
about me.
yeah.
It's about you.
That's
Right.
right. That's
but
right.
also, don't you think? Well, there's a lot of naivete that goes with being an employer and an employee, but for employees, maybe a little bit more, and this belief that they've been wronged, not been put in the right situation, and that this is a litigious world, and that employers don't want to be in a legal situation.
That's right. Absolutely.
So just the threat of something is sometimes bad for employers.
Well, what I try to do whenever possible is I want my clients to know before you're making a decision that you think comes with any degree of risk, because somebody may have raised an issue in the past, or you just have an uneasy feeling, or you're confused about the area of the law or the facts, that's a good time to turn to me and talk to me in advance of making a decision, so that I'm not having to engage in cleanup work after the fact, but I'm helping advise you on the front end and helping you make a decision which hopefully will be as bulletproof as possible.
David, if someone did want to get hold of you, how would they find you?
You can find us on my firm's website, which is www.constangy, CONSTANGY.com. You can always email me at dkurtz, DKURTZ, @constangy.com. Or if you want to go old-fashioned and give me a call, it's 617-849-7885.